Hi, I'm Brenda Cossman. I'm the director of the Bonham Centre for Sexual Diversity Studies, and I will be your cruise director for this afternoon's panel discussion. I'm delighted to welcome you here to the panel on BDSM, consent, and the law. We strongly encourage people to tweet, and only ask that if you are tweeting the event to please use the hashtag BDSM law. I know it's really catchy, but it seemed to do the trick. So, a few weeks ago, our country went into a kind of collective convulsion around the Jian Ghomeshi revelations. Ghomeshi's initial post on Facebook claimed that he was being framed and fired for what was consensual BDSM. Now, since that time, we've learned some other things. Some other revelations have come into play that have cast more than a little bit of doubt on the consensual piece of that story. But that initial claim, it was the initial claim that raised some broader questions around BDSM and the law, BDSM, consent, and the law. And both Andrea Zanin and I, rather quickly out of the gate, I might add, seized the opportunity to raise some questions in the broader public debate around BDSM, consent, and the law from very different perspectives. Me from the law, her more from BDSM, and yet we did this tag team all week long in a number of different publications. Now, this panel had its genesis in those discussions, which turned out to have more than a little bit of traction. Who knew so many people were interested in BDSM, consent, and the law? Both Andrea and I went a little bit viral that week, which is really what brought us here. Now, the Ghomeshi story has traveled a long way since that time. And I think one of the things we want to do here, one of the things that I want to do just to start off with, is to emphasize what our panel is not about. There's a lot of things that this panel is not about. The panel is not about the failure of the criminal justice system around sexual assault. The panel is not about why complainants or victims of sexual assault don't come forward. The panel's not about the legitimacy of a defamation claim when an employee is covered by a collective agreement. These are all terribly important questions, some more than others. You know, the employment question, the sexual assault question has actually come to take a real center stage in Canada in the last couple of weeks. But that's not what this panel is about. It's not that it couldn't be. It's a really important topic that could be the focus of a panel, but you'd need a different set of experts in order to address that. So we don't want to downplay the importance of that. That's just not who we are, and that's not what we're here to talk about. So what we're here to talk about today really is BDSM, consent, and the law. From a range of different perspectives. What does consent look like in BDSM? How does the law understand BDSM? How does or might the law deal with consent within BDSM? Now, I'm just going to speak for a few minutes. I'm then going to, introduce our panelists. They will each speak for about 15 minutes, and then I'm going to ask them some questions, and then we will open it up to a Q&A. But I just wanted to give just a little bit of background, really just coming from my own intervention in this debate early in the day with the piece that I wrote in the Globe and Mail. So basically, the point that I threw out was that a person cannot consent to assault causing bodily harm. Now, Hamish will correct me, as he tends to. That it's not that you can't consent to bodily harm, it's that the consent is vitiated in the case of bodily harm, and he will explain to you the important distinction between what I said and what he said. But my point to him is when you write for the Globe and Mail, you don't use the word vitiate. You just say you cannot consent to assault causing bodily harm. Now, if a sexual practice causes bodily harm, then it doesn't matter that a person consented to it. The Supreme Court of Canada, in a case quite a while ago called Jobidon, people think that there was a recent Supreme Court of Canada case that involved the choking case. It's not this one. It's one that goes back much longer ago. And it dealt with a barroom brawl. And the Supreme Court of Canada in that case said that it didn't matter that the participants had consented to the fist fight. Now, admittedly, one of the victims died in this fist fight, but it was ultimately just about the question of the participants had gone willingly into this and had a barroom brawl, had a fist fight. Was consent relevant? And the Supreme Court of Canada said no. No, you cannot consent to assault causing bodily harm. The Supreme Court of Canada, though, also set out a little exception to this basic rule, and this is something that I wish I had said on my first intervention, because that apparently became the focus, the entire focus of the comment section, which of course I don't read, that they carved out, the Supreme Court of Canada carved out a clear exception, which included rough sports. Important things like hockey and boxing, where a participant can consent to assault causing bodily harm. Because these are activities that have social value. And in fact, it included, in addition to rough sports, hockey and boxing, it includes medical intervention, surgery, stuntmen creating a socially valuable product, that's verbatim, and tattoos. These were things that you can actually consent to, but other than that, if you are just in a barroom brawl, there is no social value in that, and so you can't consent. In a case a couple of years later, decided by the Ontario Court of Appeal, a case called Walsh, the Court of Appeal took that reasoning and applied it to a sexual context, and applied it to what was described as, and I think fairly described as, a BDSM encounter. And according to the court, this was not a context in which a person could consent. In other words, rough sex was not like rough sports. Rough sports are okay, they have social value, but rough sex did not. Of course, the problem with everyone tweeting now is it's all coming up on my phone. Keep going. Now, this presents more than a bit of a challenge for practitioners of BDSM, and at least for the practitioners of some types, practitioners of some types of BDSM. If the practice causes bodily harm, and bodily harm is defined as non-trivial or non-transient injury, then a person can still be found to be guilty of assault, notwithstanding the consent. Now, my statement of the law is not without controversy. Karen Busby, professor of law at Faculty of Law at University of Manitoba, says that I'm wrong. Now, this isn't the first time Karen Busby has said I'm wrong. We have a history of debating respectfully. In her reading of the case law, consensual BDSM is not at risk. Now, she looked at all of the cases that were decided after Walsh, up until I think 2011 or 12. And she said that, that looking at these cases, consensual BDSM is at risk. Now, I read these cases really quite differently. All the post-Walsh cases that raised BDSM as a defense, they all tried to raise BDSM as a defense in sexual assault cases, and they raised the so-called BDSM defense, which is neither BDSM nor a defense, I would say. Now, as Busby describes, and here I completely agree with her, most of the cases involve the assertion of consensual BDSM in little more than a pretense to justify extreme violence. Now, each of these cases effectively involved a case that was a case of sexual assault, where the accused just said, no, it was just BDSM. And all of these cases, the court found that it really had nothing to do with that, and that there was, in fact, no consent in all of these cases. Now, I agree with that yes, it was little more than a pretense to justify extreme violence. But the issue in these cases then was not, could the complainant consent to the practices? It was, did the complainant consent to the practices? And in each of the cases, the courts basically say, no, there was no consent. So the cases leave open the question about, could you consent to these practices? And for me then, that question remains unanswered, or it remains answered by the earlier case of Walsh, which specifically said that assault causing bodily harm in the sexual BDSM context cannot be consented to, or that the consent is vitiated, leaving, I think, the BDSM community in a precarious legal position. Now, for the most part, this is, of course, a victimless crime. If both parties consent, then there's not going to be a complainant coming forward. So there's no way really for this to come to the attention of law enforcement authorities. But then I think, but what if something goes wrong? What if something goes wrong? And, you know, people involved in close, intimate, emotional, sexual relationships, what could go wrong? What could possibly go wrong? So what if someone changes their mind or undergoes a change of heart or undergoes some trauma? It is humans, after all, and their sexual relationships. So, you know, stuff can go wrong. What would the law do? It might vitiate the consent. And that's what we're going to hear about today a little bit. Well, we're going to hear different things. Hamish is going to tell us a little bit more about the criminal law. Kyle is going to tell us a little bit more about how the law views BDSM more generally and how it fits within the criminal law's regulation of sex on the margins. And Andrea is going to tell us a little bit more about BDSM and consent. But alas, I need to introduce them. Hamish, at the end, I'm introducing them in the reverse order in which they will speak for no particularly good reason. Hamish Stewart is a professor of law at the University of Toronto, where he teaches and writes in the area of criminal and evidence law. He's authored and edited 4 books, including Sexual Offences in Canadian Law, only marginally on the point of today's topic. One of his articles is entitled The Limits of Consent and the Law of Assault. He admits to knowing little to nothing about BDSM that he has not read in the cases, which he recognizes may not be the best description of BDSM. Kyle Kirkup is an SJD student at the Faculty of Law, University of Toronto, and also a holder of the prestigious Trudeau Scholarship. He's a 2013 Trudeau Scholar. His doctorate explores the role of law in, or the role of the criminal justice system in both producing and contesting contemporary norms around gender and sexual identity. He's already published extensively on, you know, stuff about sex and the law. Many of you will recognize him from his many media appearances and opinion pieces, including in the Globe and Mail. These days, if I want to get out of the gate fast, I got to, you know, be faster than him. He's a rising star in the area of sexuality in the law. Now, I know Kyle pretty well. I'm one of his supervisors for his doctorate, and he was the conference organizer for this little shindig called the World Pride Human Rights Conference that we organized. So I know him fairly well, but I think as evidence of his rising stardom, a student recently came up to me and said, "You actually know Kyle Kirkup?" I said, "Yeah, I do." Andrea Zanin is a PhD student in gender, feminist, and women's studies at York University. Now, this is also where I put this in way too small a font for myself. What was I thinking? Her research on early 1990s Canadian SM dyke porn in the context of Canada customs censorship will be published in a forthcoming volume, Activating Resistance, Remembering and Rethinking Sex-Gender Struggles with UBC Press. Andrea has been teaching about queer sexuality, non-monogamy, and BDSM leather internationally in both community and academic settings for over a decade. She's written about sex relationships and kink for numerous magazines and newspapers, and has a fantastic blog called Sex Geek, sexgeek.wordpress.com. If you haven't read it, you must. Her SM fiction, she didn't write that part. I'm the one who's like, Sex Geek is completely awesome. Her SM fiction appears in various anthologies, as well as she co-organizes the annual Canadian Leather Dyke Weekend, an Unholy Harvest, and runs a pervy book club called the Leather Binding Society. Now, since Andrea and I only just met through our tag team appearances this week, through a couple weeks ago, through the the early days of the Ghomeshi feeding frenzy, I don't really know her well enough to make fun of her like I did the other two. So, with no further ado, though, let me ask Andrea to come up.
Thank you, Brenda. I am sure we'll get there. So thank you to Brenda for inviting me to speak on the panel, and to my fellow panelists for letting a non-lawyer infiltrate your mysterious society. I expect you will teach me the secret handshake later. So I have a lot of sort of conceptual framework stuff that I wanted to put out there. And it's way longer than 15 minutes, so I'm condensed, and anyway, bear with me, I'll do my best. So just a historical perspective to start with, because that's where most of my study has been located. The values that underpin the work of early sexologists like Richard von Krafft-Ebing and others, his contemporaries and his successors, was very much based in a normal versus deviant model of sexuality, which is to say, broadly speaking, married reproductive sex was normal and therefore good, and everything else was deviant and therefore pathologized. And for some strange reason, the sexologists thought it would be a great idea to do some extensive cataloging with many, many case studies with lots and lots of somewhat salacious detail about what exactly all of those pathologies look like. And you can go read it, it's fascinating. This is, this basic framework is the one in which I think today's sort of LGBTQ activism has done an enormous amount of work to change, right? And mostly the framework, there's two main ways in which this framework has been attacked in more recent activism and dating back a long time too. And that is, one way to attack that framework is to say, well, it's not broad enough. We want the normal, healthy to include us too, right? And so there's been some efforts in the direction of expanding that to include more people and more groups, right, or more activities. Another current, and they really do sort of work hand in hand, even though they sometimes go head to head, is the one that would say this model entirely needs to be scrapped. And what we actually need to do is put into place a different model of understanding sexuality, which is to say one that is about the distinction between consent, desire, agency, and empowerment, and force, coercion, non-consent, etc. Right? So this sort of is a different model than the normal versus deviant model. It's less about what exactly you do and more about why you're doing it, et cetera, how it gets done. And this same approach is the one that this same sort of split approach you also see in kink, right? Anything to do with BDSM, kink, leather, fetish, these broad umbrella terms. The same more or less has happened in activism within BDSM and kink, right? Which is to say that there are people within the sort of BDSM kink community who are looking to say, well, it's really just like intense foreplay, or there's a sort of vaguely assimilationist current that happens around what BDSM is, and that can be really useful because we see things like, I don't know, 50 Shades of Grey, everybody's excited about it, right? Like, I got lots of problems with the how and the why, but the what is actually not that freaky, right? In terms of actual BDSM. It's quite mild, and that sort of thing, that sort of mainstreaming is one way of approaching BDSM activism and changing the conversation. The other way is to say, we really shouldn't have to justify what it is that we're doing, as long as we are doing it in a context of risk awareness and of endeavors towards safety and of consent and desire and full agency and autonomy on everybody's part, right? And so you can see this split that happens in a lot of the way these things are approached. So as a person who's been studying as much as I can get my hands on for many years now in relation to BDSM, one of the things that I have been, to be honest with you, quite shocked by is that in most of the scholarly literature on anything to do with sadism, masochism, BDSM, scholars don't define their terms. It feels like this weird blip in the way that scholarship is generally done. Because in my experience, that's one of the first things they teach you to do as a scholar, is really clearly define the terms of what you are talking about if you're going to then build an argument. But most literature on BDSM does not do that. So I decided to write one myself. And I'm going to ambitiously suggest that scholars use it. One day I will publish it. And I think that one of the key pieces for me in this is that it, in my opinion, I get that it's a bit self-serving, but I think practitioners need to be the one doing that kind of defining, or at the very least informing it. And so coming into grad school and ever since being there, I'm very, very out as being a practitioner of BDSM, and I think that's a really crucial and important detail, because I think people who are coming from sort of an inner, sort of insider knowledge space, which is the term we use in research, can come up with a different kind of analysis than people who are, whether they're stating it or not, they're sort of coming at it from the outside. I didn't phrase that well. What I mean to say is that there are a lot of scholars who are big perverts. There really are tons, but there are very, very few of that number that actually say so. So some of the knowledge that's been produced, and you can sort of read between the lines when you know what to look for, you can tell it's by somebody who kind of knows it from the inside, and you can tell when it's not. Doesn't mean I necessarily agree along those same lines, it's just interesting to note. So I've come up with a 5-part definition, but I'm going to give you just the first 3 because I think they're the most important and the ones that are probably the most relevant here. So the key piece to understand is that everything that we see that falls under the very, very broad understanding of BDSM, leather, fetish, kink, and related terms, right? For the purposes of this, throw them all into a big bag and shake them up. They kind of overlap. The idea here is that any one of these 3 parts of the definition can be enough to sort of quote unquote qualify somebody, right, as doing this thing, but you can't tell from the outside which one's happening, and they may be overlapping and happening more than one at once. So part 1 is power, and by this I mean the heightened erotic tension that is linked with taking up or giving over more power and authority than is normally considered acceptable within the context of an interpersonal romantic sexual relationship. It can take the form of consciously theatrical role play, which is to say people sort of dressing up in costumes and doing things that are not supposed to be them, right? But it can also take the form of injecting in a really conscious way, sort of suffusing everyday dynamics with power differentials deliberately and consciously and for the mutual pleasure of all concerned. Part 2 is pain. And by this, I'm not talking about bad pain, like I ate bad seafood or I stubbed my toe, but rather the enjoyment of intense stimulation. Often, although not always in combination with erotic arousal. And I will say a lot more about that in a bit, so hold that thought. Part 3 is fetish. This is my personal favorite, because human beings are so damn creative. So for this, when I talk about fetish, I talk about the eroticization of objects, body parts, or sensory stimulus that falls outside the classic catalog of what's considered normative, which right there is a problem, right? But mostly, the short idea is fetishism is on a continuum of intensity. So you can have fetishists that sort of more or less like, you know, I like shoes. I really like shoes. Well, that's about it, right? Or you could have people who all the way at the other end of the spectrum cannot achieve erotic satisfaction without that object or smell or experience or sound being present in their sexual interaction, and everything in between. So again, SM practitioners or BDSM practitioners can engage in one or more of these, sometimes all together, sometimes separated, not necessarily all 3. Some people just live in one of those little pieces, and some people do a big combination. So as a mental exercise, when I'm teaching a 101 class, I ask students, and I won't go into it at length here, but I will ask you to sort of do the project in your head. Picture the following, okay? There is you've decided you're going to the BDSM party. You walk in the door and you see a man kneeling and licking a woman's boots. That is the image that you've got. You can come up with, using my 3-part definition, at least 10 to 12 very plausible scenarios of what might actually be going on for those 2 people. This could be about pain, it could be about fetish, it could be about power, it could be any number of combinations in a range of directions, and you cannot know from the outside by looking in. So if you just try to, I mean, if I just said 10 to 12, try it for fun. See if you can come up with 10 to 12 different ways that that scenario could mean different things, and that's where the meaning of SM really sort of becomes a thing. So we have a couple of acronyms in the SM world to talk about this. One of them, and they're very long and funny. So one of them is WIITWD. That stands for what it is that we do, because we can't always explain it. The 3-part definition helps with that, right? And another one is, okay, let me see if I can get this one. YKINMKBYKIOK, which stands for, yeah, you were trying to get that down, hey? Your kink is not my kink, but your kink is okay. Which is actually really important, because I think this, to me, the fact that we can make these things funny indicates that we actually really know that we can't tell from the outside. Or that what someone thinks is really sexy, we'd be like, whoa, I never even, you liked what? Like it's, right? And that big diversity all gets sort of put together. So I want to go back to this idea of pain, because I think that's where most of the question of bodily harm ends up living. And so I wanted to take a moment and focus on the reasons why people might partake in play that causes bodily harm of one sort or another, particularly lasting marks, and how we see as practitioners the value or the meaning of it, and how we navigate the potential for injury. So I came up with, in a little brainstorm, and I'm assuming that some of the pervs in the room might be able to add more to this list, but this is sort of my basic starting point list. One of those items would be decoration. One of the reasons we might do it would be decoration, right? This is sort of points to the connection between BDSM and the body modification community. So tattoos, piercings, scarification, branding, art, various other ways of changing the body. Thank you. And sometimes we do that ourselves or with each other, and sometimes we hire professionals. But the pain of that process is sometimes part of the point, or helps make it more meaningful or symbolic, including the healing process. Another one is an endorphin high. We talk about this a lot in community. It's basically the body's chemical reaction to intense stimulation or pain. It's a chemical high, and it's all natural. Another one would be ordeal. So this can be about desiring the experience of testing, proving oneself, initiation rites, finding a sense of yourself as strong or capable, or even to earn an external reward. There's a concept in some communities of, for instance, earned leather, where the gifting of a piece of leather is a very symbolically meaningful thing that you can achieve by doing a thing. It's very vast. Another one is spirituality and religion. Many people see deep compatibility between their spiritual or religious practices and their BDSM practices, whether that's sourced from your own religious heritage, for instance, early Catholic flagellation, or invented or for a new sort of freshly adopted religious practice like neo-paganism. Pain can be incorporated into a number of those religious practices. Another one is personal ritual or symbolism. Apart from the spiritual context. In North America, broadly speaking, we don't have a lot of rites of passage. Pardon me. And in BDSM, we create our own a lot of the time, whether that's to affirm somebody's gender identity, mark a transition into or out of a committed relationship, solidify a group dynamic, support somebody in a grieving process with the loss of a partner, a child, a parent, or even celebrate a birthday. Yes, birthday spankings count. And some of these we really kind of create ourselves. Sometimes we get inspiration from, or even directly appropriate things from, for instance, First Nations ritual, which has its own set of problems, and other kinds of ritual from various cultures around the world. Another item would be submission. Some people choose to endure pain that they don't physically enjoy because it enhances or sustains a power dynamic, which itself they very much do enjoy, emotionally, psychologically. So in this case, the pain is symbolic. It's a gift, for instance, that a submissive offers to a dominant, and sometimes it can be the only way to reach a state of really deeply felt psychological submission, which they very much want to achieve. I have 3 more, and I will wrap up as quick as I can. Another one is catharsis. SM play, intense physical stimulation, can provide an emotional catharsis through physical stimulation. Some people seek out particular types of play in order to be emotionally cracked open and achieve a kind of release. And that's a welcome thing in the hands of a trusted partner. Sometimes it's screaming and crying, sometimes it's more quiet, but it's an emotional drive. Pardon me. Emotional intensity more broadly. Some people, for instance, fear pain, and they really like the thrill of the fear in the same way that we go to a horror movie. And my last one on the list is difference in sensation. Some people are straight up hardwired, this is not a scholarly opinion, it's just observation, to enjoy deeper, harder, rougher, or otherwise more intense stimulation than average. For some people, the experience of light touch or tickling is excruciating, and the only thing that feels good is a deeper or harder stimulation. And that's, I think, probably something you could learn more about in neurology if somebody ever decided to study it. Because we know who they are. There are people who just want more and who don't enjoy something less, and that's it. So just because something would hurt you doesn't mean it would hurt the next person or feel the same way, and pain is terribly subjective. We all know this. So depending on the type of practice that creates these marks, we have a range of safety protocols, much as if you were practicing an extreme sport. And we do extensive negotiation. I wrote about this in my Globe and Mail article. I don't know if I want to sort of go over a lot of it right now because it's already out there, and I was more interested in giving you sort of some background. But the short version is we do before, during, and after. So there's usually extensive negotiation of one sort or another before an activity takes place. There's a set of signals, whether that's safe words or body language or straight up communication during a scene that's happening, to sort of indicate ongoing consent and enjoyment, or how close somebody is to hitting a limit. And then we also do aftercare. which is to say we check in afterwards, immediately after what we've done, and possibly later on as well. And then bonus round, if you had a really good time, this is also a great place to talk about it so that you can go back and do it again. So it's a sort of full set of systems that gets put together for this. So I'm clearly not the legal expert here as far as the rest of the details go. But I do want to note that, you know, like how it didn't work to make gay illegal? It doesn't work to make kink illegal. This is part of benign human sexual diversity. It's been around since the dawn of humanity. It's not going to change. The thing that does change is whether or not practitioners feel that they need to be careful and hide what they do. And the hiding sometimes is the most dangerous thing of all, which is to say that some of us are drastically underserved by mental health and health services, either because we are afraid of being pathologized or because it has happened. We are afraid that if we have marks on our bodies and we go see the regular doctor just for a checkup and they notice it, that our partners will be in trouble for some sort of abuse accusation. So people sometimes avoid healthcare appointments. And there is almost nil in terms of history of successful cases of sexual assault that happen in a kink context, a real actual kink context, that have actually gone to trial and resulted in anybody being convicted. There's a scholar named Thomas Macaulay Miller who's done a lot of research on this. So essentially that means we're left to self-regulate, which works sometimes and sometimes doesn't, because the systems in place don't work for us. Don't want to go too far over time, so I'm going to wrap up. Thank you. I hope I've framed this as well as I could. If you have more questions, I'm happy to take them later. Thank you.
So thank you all for coming. It's a real honor to be here for this really important conversation about the legal regulation of BDSM. So today I want to explore the two competing and at times contradictory frames that are invariably used and invoked and reinscribed when we conceptualize the legal regulation of BDSM in Canada. So on the one hand, Canada has this long and misguided history, one that continues to the present, of criminalizing sex that dwells at the outskirts of intelligibility. So when it comes to the regulation of non-normative sexualities, Canada and Canadian criminal law continues to be used to police the borders of good sex and bad sex. But on the other hand, Canada has another history that also continues to the present, one of refusing to take gendered violence and sexual assault seriously. So this conceptual frame emphasizes the extent to which a wide array of actors in the criminal justice system, lawmakers, police, lawyers, continue to rely upon deeply entrenched notions of gender and sexuality in an effort to unfound sexual assault complaints. So when it comes to the contemporary regulation of BDSM, we see the tension between these two overlapping frames that I don't think can be easily resolved, and we see them being restaged again and again in the jurisprudence. So on the one hand is the heavy moralistic hand of the criminal law emerging to regulate sex between consenting adults, or, on the other hand, should we be skeptical of attempts to use the criminal law as really just a tool of patriarchal violence? So while the tensions between these two conceptual frames emerge when we talk about BDSM, my central claim today is that it also plays out in the context of two other contemporary legal controversies. The first is the criminalization of adult sex work, and the second is the criminalization of HIV non-disclosure. And while it may never be possible to resolve these tensions, it's crucial that we start to conceptualize the legal regulation of adult sex work, HIV non-disclosure, and BDSM by recognizing the complexity of the questions at hand, which may indeed be symptomatic of much larger contradictions of the criminal law. And I think these are contradictions that cannot be papered over, but rather must actually be critically engaged, exposed, explored, and acknowledged, and that's what I'm hoping to do here in the brief time that I have. So let me start by saying a few words about the first conceptual frame, which emphasizes Canada's long and misguided history of using the heavy hand of the criminal law to target non-normative sexualities and regulate on the basis of morality. So the typical story that we often tell within this frame is that until 1969, homosexuality was by its very definition a criminal identity. In 1969, the federal government famously amended the criminal code, the prohibitions against sodomy and gross indecency, and the result was that sex between two consenting adult gay men would no longer be a crime, so long as it took place in private and between participants aged 21 years or older. So in view of this history, a history that continues into the present, a first conceptual frame of criminal law emerges. One that tends to remain deeply skeptical about any attempt to use the heavy hand of the criminal law to police the borders of good sex and bad sex between consenting adults. But at the same time, Canada has this other competing frame that is often in conflict or in contradiction, and I think that we have to really expressly acknowledge this second conceptual frame. There is this other long and misguided history, again one that continues to the present, of failing to take sexual assault and other forms of gendered violence seriously. This conceptual frame, for example, is deeply critical of the earliest definitions of rape in the criminal code. The 1892 version describes rape as being, quote, an act of a man having carnal knowledge of a woman who is not his wife without her consent. So that's from 1892. And through history, we see changing norms of gender and sexuality being invoked and deployed in the criminal law, most famously with the 1983 reforms to the law of sexual assault. So we see this discursive shift from rape to sexual assault. We see a shift from this being, a sexual offense to a violent offense. We see this shift away from a heteronormative definition of sexual assault, and we see this shift that removes the marital rape exemption from the criminal code. But despite these legislative changes, again, the criticism that continues to be launched at a wide array of actors in the criminal legal system is that when investigating and prosecuting sexual assault complaints, police and lawyers tend to rely upon deep-seated tropes about gender and sexuality, and in the process, they systemically re-victimize women who have experienced male violence. So in view of this second history, one that continues into the present, this conceptual frame emphasizes the criminal law's failure to take sexual assault seriously, and it remains deeply skeptical about attempts on the part of defense lawyers and others to limit the application and the promise of the 1983 Criminal Code reforms. So these two competing frames, which I think at times are very much in conflict with each other and overlapping, and I think we have to address the conflict. They shape out not only when we think about the legal regulation of BDSM, but also in two other contemporary legal controversies. The first is the legal regulation of adult sex work, and the second is the criminalization of HIV non-disclosure. So let me start with sex work. So as we know, in December 2013, the Supreme Court of Canada struck down 3 of Canada's former prostitution laws in the landmark decision in Bedford. The Supreme Court found that all 3 of these provisions violated sex workers' rights under Section 7 of the Charter, and the court gave the government 1 year to enact new legislation. Now, last week, Bill C-36, which is the government's response to the Bedford decision, received royal assent, and it will come into force in early December. So there are at least 2 frames of the criminal law that I think can be used to understand the controversies swirling around these recent legal developments. So when viewed from the vantage point offered by the first criminal law frame, Bill C-36 might be properly understood as reflecting yet another misguided attempt on the part of the government to use the heavy hand of the criminal law to regulate on the basis of morality. Indeed, on the day that Bill C-36 was tabled, Justice Minister Peter MacKay invoked moralizing discourses, noting that the legislation was designed to target, quote, the perpetrators, the perverts, and the pimps, end quote. Others, those who have tended to occupy spaces, and there are a multitude of different positions within this second frame, have viewed this legislative response of Bill C-36 in far more positive terms. Some drawing upon the theoretical frameworks offered by radical feminist thinkers such as Catherine McKinnon, have framed sex work as little more than a practice of sex inequality. And Bill C-36, they have argued, should be applauded because it promises to harness the expressive power of the criminal law in order to send important societal messages about gender inequality. So let me shift gears now to talk a little bit about the ways in which these two frames also play out in recent controversies surrounding the criminalization of HIV non-disclosure. So in this context, the first case that we talk about is the 1998 decision of the Supreme Court in Courier, where the Supreme Court held that people living with HIV have a duty to disclose their status whenever there is a, quote, significant risk of serious bodily harm. That's the test. More recently, the Supreme Court clarified that this initial test, which had left people living with HIV in a great deal of uncertainty about where and how they had to disclose, really meant a, quote, realistic possibility that HIV will be transmitted. So the court's analysis of HIV non-disclosure has been met with both considerable criticism along with considerable praise. So critics have tended to adopt this first frame of the criminal law, arguing that criminalization and moralizing sanctions lodged against people living with HIV are emblematic of a larger law and order trend in Canada, and they have been very skeptical about putting people in jail for longer periods of time in an effort to sort of create a very meaningful and robust conception of consent in the law of sexual assault. Now, those who are generally supportive of criminalization have tended to adopt positions within this second frame. They have tended to make arguments that go something like this. If you take consent and bodily integrity seriously, then the logical conclusion is that an individual's failure to disclose their status before sexual activities occur should be treated as a harm that is properly addressed by the criminal law, and as such should be viewed as an aggravated sexual assault. So criminalizing people living with HIV, the argument goes, is not moralizing, but rather a meaningful and robust treatment of the law of consent and sexual assault. So this leads me now to the heart of the matter that we're talking about today, which is the legal regulation of BDSM. So as Professor Brenda Cossman just noted, we have this 1991 decision in Jobidan, which involves this barroom brawl, where the Supreme Court held that for policy reasons, consent does not render assaultive behavior legal where there is, one, an intention to cause bodily harm, and two, bodily harm results. So the Supreme Court then walks through these series of examples, these socially valuable examples, to say, but there are some things that people can provide legally valid consent for. The court notes that these activities, such as stuntmen, have a, quote, positive social value, and the intent of the actors is to produce a social benefit for the good of the people involved, and often for a wider group of people as well, end quote. So in the 23 years since the Supreme Court issued this decision, this rule from Jobidan has slowly made its way from the barroom to the bedroom in a series of BDSM cases. As Professor Cossman just noted, we have this seminal decision from the Ontario Court of Appeal in 1995 called Welch, where the accused claimed that he and the complainant had been engaging in consensual sex that involved restraint, hitting, and aggressive penetration. The complainant maintained throughout that she did not consent to these activities in question, and in upholding the conviction in a trial before a judge and jury, the Court of Appeal explained, quote, although the law must recognize individual freedom and autonomy, when the activity in question involves pursuing sexual gratification by deliberately inflicting pain upon another that gives rise to bodily harm, then the personal interest of the individuals must yield to the more compelling societal interests which are challenged by such behavior. So in this quotation, I think we see the discursive tension between those two frames, this frame of sexual autonomy and freedom on the one hand, and then this societal interest more generally. In its 2011 decision in JA, the Supreme Court was tasked with determining whether, in the context of an erotic asphyxiation encounter, consent for the purposes of sexual assault required the complainant to be conscious throughout the activity. So, both the majority opinion and the minority opinion refused to affirm the lower decision of the Ontario Court of Appeal in Welch, not necessarily because they agreed or disagreed with it, but rather because it was not an issue that was properly before the court, because for a procedural reason and based on the dissent at the Court of Appeal in JA, the issue was just not live for the court. And as Chief Justice McLaughlin explained, quote, "Since the issue of bodily harm is not before this court, I take no position on whether or in which circumstances individuals may consent to bodily harm during the sexual activity." So in doing so, this decision in JA from 2011 seems to leave the door wide open for a future case to make its way to the Supreme Court involving BDSM, and the court will either affirm the rule developed in Welch or reject it. More recently, there's this 2013 decision in Zhao where the Ontario Court of Appeal appeared to be retreating slightly from this 1995 decision when they stated, quote, "The social utility of intimate sexual relationships is significantly different from that of consensual bar fights. As such, the underlying policy reasons for the ruling in Jobidan cannot be generally applicable in a sexual context as suggested by the ruling in Welch." End quote. So as this line of cases has developed over the past 23 years, this contested relationship between the two frames of criminal law has been restaged again and again. So relying on the first frame, one that remains skeptical about the criminalization of non-normative sexualities, scholars and activists have objected to attempts to impose limits on the contours of consent involving bodily harm between consenting adults. Like sex work and HIV non-disclosure, they have tended to argue that the practice of BDSM should not be forced to continue to dwell in the shadows of the criminal law, always carrying with it the risk of criminal prosecution. They are also concerned that cases developing the legal parameters of consent and BDSM invariably invoke and reascribe moralizing discourses. The Court of Appeal decision in Welch, for example, noted that the complainant's consent, quote, "cannot detract from the inherently degrading and dehumanizing nature of the conduct," end quote. Indeed, this language echoes that of the preamble of Canada's new sex work legislation, which makes reference to, quote, "the social harm caused by the objectification of the human body," end quote. Those in this camp also point to cases, perhaps most notably a 1992 decision from the United Kingdom, the House of Lords, in Brown, where the police stumbled upon a series of videotapes involving BDSM practitioners, and the practitioners were subsequently convicted, even though no one had ever reached out to the police with a complaint. At the same time, other scholars and activists have relied upon this second frame of criminal law to emphasize the extent to which claims of BDSM are often used to paper over and mask what is really properly understood as patriarchal violence. In particular, they have expressed concern about efforts on the part of defense lawyers and others to water down the important victories from the 1983 reforms to the law of sexual assault, and they've argued very strenuously that this has been the case by defense lawyers in cases such as Welch and JA. So Professor Karen Busby has expressed concern with what she calls idealized visions of sexual autonomy and appropriated notions of BDSM. Put differently, she argues that BDSM becomes this Trojan horse that has the capacity to undermine the important work done by advocates to change the law of sexual assault. So, very briefly, to conclude, it may never be possible to resolve the discursive tensions that exist between these two competing accounts of criminal law. These tensions are restaged again and again, expressing themselves when we explore difficult questions about the legal regulation of BDSM, sex work, and HIV non-disclosure. And indeed, rather than trying to resolve this tension, we may well find it more useful to carefully think through the deep-seated contradictions inherent in the criminal law that must be continuously explored and acknowledged in our analysis of the legal regulation of BDSM. And with that, I'll leave it there. Thank you.
Okay, I guess the first thing I should say is that my role in this panel, given the high level of humor exhibited by the three previous speakers, my role is clearly to be the straight man in this session. And I would like to add to what Brenda said at the beginning. I don't know anything about this practice of BDSM apart from what I hear on Lou Reed's songs for the Velvet Underground from the 1960s, which makes me also, I guess, the old man on the panel. At any rate, my presentation, unfortunately, is going to overlap a little bit with Kyle's and with less theoretical sophistication, I would say. So what I want to do is try to present to you some doctrinal features of the law of sexual assault, which I think potentially cause problems for practitioners of BDSM. That's what I see myself as doing in this part of the presentation. So, sexual assault in the criminal code has basically the following three elements that the prosecution must prove beyond a reasonable doubt in each case. First, that the accused intentionally touched the complainant in circumstances of a sexual nature, and that's often very easy to prove because it will often be admitted. Second, that the complainant did not voluntarily agree to the sexual activity in question. And as you know, this is often a difficult point for the prosecution in sexual assault cases. The sexual activity in question, according to a recent Supreme Court of Canada decision, means the specific sexual act engaged in and the personal identity of the person who was doing it, the partner. And the third element, which is also often problematic in prosecutions, is that the accused either knew that the complainant had not communicated consent, or he did not take reasonable steps to ensure that the complainant had communicated consent. That's essentially those, of course, these things are always more complicated than they sound at first, but that's essentially the elements of the offense of sexual assault. Now, so far, this doesn't seem to create any particular problems for BDSM, and as was said previously, if you think it's all about consent and autonomy, that seems to fit fairly well with it in this framework. But there are three additional legal doctrines around sexual assault that complicate this picture and may cause difficulties. And Kyle has already mentioned one of them, and I'm going to talk about two others as well. So the first one I want to mention is one Kyle didn't mention. In a case called You and Chuck in 1999, the Supreme Court of Canada said that there was no such thing as implied consent in the context of sexual assault. And I understand why they said that. They said that because they didn't want to be hearing any more from accused people, well, I thought there was consent because there was no resistance, or I thought there was consent because there was passivity. They didn't want to hear that anymore. And that's why they said there's no implied consent to sexual touching. Nonetheless, I think this creates a problem for a practice like BDSM, because the role of implied consent in the law of assault is essentially to say that you can consent to an activity during which you may not consent to everything that occurs in that activity. You can withdraw your consent by withdrawing from the activity, not by rejecting individual instances of touching within the activity. Now, where this idea of implied consent, of course, applies most importantly is in hockey. There's a whole series of hockey cases about this, where the question is, was the force exerted by the player who is charged with an offense within not the actual consent of the other player, but within the implied consent that goes with that activity, with the level of force that's associated with that activity as an activity. So if there's no implied consent to sexual touching, then that probably means, unless the court will reconsider this, that there can't be any consent to it may create problems about there being consent to a sexual activity that has structures and rules. That's the first part that I'm a little bit concerned about, or that you should be a little bit concerned about. A second, and Kyle did advert to this one, in JA, the Supreme Court of Canada said there was no such thing, or the law would not recognize, rather, I'm not going to use the word vitiate, okay? I'm just not going to. I might use the word sedulously at some point, but I'm not going to use the word vitiate. Though I was just going to say the law will not recognize a consent that's given to a sexual touching that will occur later when the complainant is asleep or unconscious. And again, I understand completely why the Supreme Court was motivated to say this, because there is still an astonishing number of cases that involve accused people who sexually interfere with a sleeping complainant. And if the court had said, oh no, of course you can consent in advance to being sexually touched when you're asleep, in every one of those cases the prosecution would have to show that that advance consent had not been given, which would create a pragmatic difficulty in prosecuting those kind of cases. So I understand the motivation for saying it. Nevertheless, as the dissenters in JA pointed out, it does create something of an anomaly in the context of, let's say, an ongoing relationship where you might want to say to your partner, it's perfectly fine if you, tomorrow morning, if I'm not awake yet, you can kiss me, it's okay. This ruling in JA seems to eliminate that as a legal possibility. And what its implications are for BDSM, I'm not competent to say, but if there's any BDSM activity, and I don't know whether there is, but if there is any such activity that involves unconsciousness, then this JA case says, well, the law will not recognize your consent to that. Third, and the one I'm going to talk about longest, also Kyle mentioned, and he had in his presentation some of the same quotations that I'm going to use in my presentation. And this is the one that Brenda started with. Canadian law does not recognize consent to the intentional infliction of non-trivial bodily harm in situations where a larger social interest outweighs, where the court sees that there's a larger social interest that outweighs the individual interest in autonomy. Now, has already been said, this principle comes from a case called Jabadon, which involved a consensual fistfight in which one of the parties was killed, and the court refused to give effect to the consent. They weren't saying there wasn't consent. They were accepting the trial judge's finding that there had been consent, but they refused to give effect to the consent, principally on the ground that fistfighting was, in the court's words, a socially useless activity. So, in my view, for the Jabadon limit on consent to apply, there are three things the prosecution has to show. And these are different from the things the prosecution normally has to show in order to prove that an assault or a sexual assault has occurred. First, that the accused intended to cause bodily harm. Second, that the accused actually caused bodily harm. And third, that the context in which the activity occurred, the context in which the harm occurred, the activity in which the harm occurred, was one where we ought not to recognize the validity of consent because it's in some sense socially useless. This is usually how I try to summarize the Jabadon decision. Now, as has already been said, the Jabadon principle was apparently extended to sadomasochistic sexual activity in Welsh in 1995. The picture is not clear because the complainant's position was that the activity was not consensual. But the reason that the issue of whether this was sadomasochistic sex arose is that the accused said that it was. He said, well, she likes rough sex and we've done this before and this is the kind of thing she likes. It was a jury trial. The trial judge instructed the jury that consent was irrelevant. And so the question of whether consent mattered was squarely posed, even though the facts might not be as clear as you might like for this kind of case. And as Kyle said, the Ontario Court of Appeal, the jury convicted the accused, and the Ontario Court of Appeal upheld the conviction, finding that sadomasochistic sex was not one of those generally approved social purposes that can justify the intentional infliction of bodily harm. Why not? Well, one simple reason was that the court didn't mention it in Jabadon. They talk about boxing, they talk about surgery, they talk about Evel Knievel, but they don't talk about sadomasochistic sex. So that was one reason. But another reason, as Kyle said, was that the court regarded it as inherently degrading and dehumanizing. Now, interestingly, whether Welsh was correctly decided has become an issue in some of the subsequent cases on point. And where this area of the law is going, I'm not sure. I think, as Kyle said, we probably need a good test case in the Supreme Court of Canada to get some clarity around this. Kyle referred to the case of Zhao from 2013, where the Ontario Court of Appeal expressed some doubts about whether Welsh was correctly decided, and made the point that the social utility of intimate sexual relations is different, significantly different from that of a consensual bar fight, and so we shouldn't just take Jabadon and move it right over. Nevertheless, if I'm reading Zhao correctly, the bottom line in this case is still that the consent of the complainant would be irrelevant if the accused intentionally inflicted non-trivial bodily harm during sex. If you read towards the end of the decision where the court outlines what it considers to be an appropriate jury instruction on this issue, that's what it says. It says if the Crown can show that the accused intentionally inflicted non-trivial bodily harm during a sexual activity, that the complainant's consent would be legally irrelevant. So I'm not certain. I mean, Zhao does cast some doubt on Welsh, but it does not by no means overrule it. It may create some space to argue about whether it's about its application, but it certainly does not overrule it. Now, these cases are all about intentional infliction of serious bodily harm. Well, what about forms of BDSM that fall short of that? I'm assuming there are some. What about simply tying someone up, someone being tied up during sex, something relatively straightforward like that? There are not a lot of case law on this point, but what there is suggests that the law will recognize consent in that context because it falls. The court may not particularly approve of this activity. However, it's not an activity that involves the intentional infliction of serious bodily harm, and therefore it doesn't fall within the Jabadon principle, and it's probably legally possible to consent. What about role play? Andrea referred to a number of forms of role play that would not necessarily, as I understood her, involve the infliction of any harm. I believe that the law would also recognize consent to that as well. Simply, I would say that simply on the basis that if there's no harm intentionally inflicted, then this Jabadon principle doesn't apply and the court is not concerned, even if it doesn't particularly approve of the activity in question. But there is a case on point. There's a case called PA from 2013. Interestingly, in this case, there was evidence. This may be one of those cases, it's always hard to say, but it may be one of those cases Brenda was thinking about near the beginning when she said, what could possibly go wrong in an intimate relationship? Because here we had a case where the complainant and the accused both testified, and in fact, they both agreed that they had in the past engaged in various kinds of role play, including sexual role play, which sometimes included a dominant submissive dynamic, such as a teacher-student scenario. And then on the particular incident that formed the subject matter of the charge, the complainant's evidence was that she had simply not consented to what had happened on that particular occasion. The accused said, well, I think she did, and even if she didn't, I thought she did at the time, because it seemed to me we were just playing out another one of these scenarios that we'd played out in the past, which the court referred to as an assailant-victim scenario. And so there was contesting evidence about exactly which kinds of role play they had previously engaged in. But the reason I'm mentioning it is that the case is actually not about that. It's about whether the trial judge's reasons for convicting the accused were adequate as a matter of law. But the court is clearly assuming that the law would recognize the consent of both parties to these role-playing incidents where no harm was intended or caused. And so that, I think, is an interesting case that is relevant here as well. So you can see from this brief tour of the case law that it's a complicated area, and I think a lot of the complexity is generated by the two frames that Kyle referred to. The law is constantly trying. The common law is a glorious thing, but the common law's treatment of sexual assault complainants is not a glorious thing. And a lot of the changes in the law over the past 30 years have been trying to improve in this respect, and they inevitably keep bumping up against the fact that sometimes people want to do things that are not normative sexualities, as Kyle said, and that inevitably generates attention and creates these complexities in the law. So I think I will just leave it there.
So, is this on? Such a cliche, eh? Is this thing on? So I thought I would just ask our panelists just a couple of questions to get things going, and then we will open it up to some Q&A from the audience. And I guess I wanted at first maybe to get Andrea to react a little bit. Because when lawyers are talking about this, and you're surrounded by them, literally, you know, 3 law geeks and a sex geek. When we talk about the problems with the criminal law, we're using the language of intent to cause bodily harm. Now, that wouldn't be language that you would use inside the BDSM community, and yet I wonder how that might translate to the kind of different practices, for example, that you were talking about at the beginning of why people might subject themselves to these practices. So I wonder if there's a kind of translatability to what we're saying as, you know, intention to cause bodily harm. How might that play out in a BDSM context?
We often talk about hurt versus harm. We want hurt, we don't want harm. So that's the sort of very short answer to that question. I don't know if this is exactly what you were looking for, but it really does. The language that's sort of common within community is that we do not wish to cause harm, as in damage or problems or difficulties, but we do want to cause pain of an enjoyable and consensual sort. So we don't necessarily see the idea of hurt as being a wrong thing. So that's sort of the line that we end up drawing. I could talk on and on about various things, but I think that's the substance of the answer you were looking for. Were you looking for me to expand more?
A little bit.
I think, pardon me. The other thing is that, I mean, you know, in terms of how we understand, and I won't talk about harm, but I will talk about sort of lasting effect, if you will, or physical marking, is that we have a pretty intense interest in understanding how to cause the maximum visual appeal, the maximum sensation appeal, right, in terms of the experience of the thing, while minimizing the risk or possibility of those things causing unintentional damage, or, you know, sometimes to a point of almost fanaticism. We understand them as like sort of safety police types who want to sort of excessively regulate what's allowed to happen in a BDSM context itself, completely apart from any legal apparatus at all. But I mean, you know, there are ways in which the things that are most visually spectacular can actually be the least damaging, and things in which it's actually really funny, Hamish, because you mentioned tying somebody up, right, as though that were sort of an easy or fairly banal, potentially, thing to do, right? Which, I don't know. Well, I think it's commonly seen that way. Fair enough. But I mean, I think people see it that way, right? And, you know, like the fuzzy handcuffs. I mean, they're sort of pop culture cliches, right? But bondage is one of the types of play that can actually cause the most intense and serious physical damage that you would simply never see, because it would be permanent nerve damage if you did it wrong, right? People who tie in places on the body where nerves run close to the surface, there are people who know how to do bondage know how to avoid risky bondage, but do spectacular bondage, or bondage that has a strong physical effect, right? People who actually don't know very much about it and who do the 50 Shades thing and tie somebody to the bed with their necktie are actually putting their partner at much greater risk than potentially what a knowledgeable BDSM practitioner would do. On the flip side, spectacular physical harm, I'm thinking of, there was a Slate article written by, I don't know how to pronounce his last name, William Salatan, anyway, maybe 2 years ago now, and I wrote an extensive response to it because he pissed me off so much, because for shock value, he included a picture of somebody's penis tacked to a board with needles, right? And I looked at that picture and I was like, dude, that's like somebody who really knows what they're doing. You're talking about such careful placement of needles. You're talking about like pinprick level damage. There was no blood. The guy was clearly enjoying himself. There was pre-cum everywhere. It was like, you know, like, I mean, there was all kinds of physical signs that as an educated practitioner, I could look at and say, this person is doing an exemplary job of safety. There's nitrile gloves. You can just see the end of a finger in the picture. Like, everything was in place. And I mean, you could actually do more damage to yourself physically by shaving in the morning. I'm not actually kidding. You really could draw a lot more blood by shaving, right? But oh my God, it's a dick on a board, right? Like, everyone got really upset about that, and it works, right? So you have to, I mean, it's sort of like, if you, depending on what, you have to know a little more to be able to interpret what you're looking at, and that's within the context of me already having said, you can't always know by looking, right? So, but even within the context of, you can't know what the motivations are. I mean, I can't tell from this picture of this penis whether or not this was consensual, but I can certainly infer a whole lot of things from it, right? I mean, maybe the guy was, you know, tied up and kidnapped against his will, but from what I could see of the play, it was actually extremely safe and very, very minimally damaging. So I don't know if that's sort of, you know, and this is the level of detail and knowledge that I think most people, you know, if a cop busted in on that and looked at it, would have no way to critically understand what it was that was going on, and might be likely to make all sorts of wrong assumptions. So I mean, that's sort of, and I can talk a little bit more later about law enforcement and how BDSM relates to law enforcement and how problematic that can be for that reason.
Again, with some of those scenarios, I just think, you know, and what could possibly go wrong? What could go wrong? Kyle, so in other words, the law cares about consent except when it doesn't. Is that kind of the way that it goes? That we care about consent sometimes when there's non-normative sex and sexuality, sometimes we care about it and sometimes we don't.
Yeah, it's I think that's a really interesting way of putting it, because you start to see in a series of cases, I think of the decision in JA and the standoff. This is the autoerotic asphyxiation case that went to the Supreme Court in 2011. And you see this standoff between the majority and the dissenting opinion. And the majority seems to be suggesting we're just not going to go there, right? Even if you did consent in fact, you may not have been able to consent in law, because there seems to be sort of an element and a concern that, you know, the autoerotic asphyxiation context is very small, but you know, other contexts of stupefying substances, drugs, alcohol, and unconscious complainants is very real. And the Supreme Court, I think, seems to be very worried about defense lawyers trying to, again, water down those very hard-fought reforms to the law in the criminal code in 1983. And so they seem to be saying, we just won't go there, right? And I think that a lot of the debates that you see, especially in the work of Karen Busby, seems to be saying exactly that. She has this article in the Canadian Journal of Women in the Law from 2012, and she reviews the case law, and basically her analysis is, there's nothing to see here, folks. So long as you keep it sane and safe, you're very unlikely to ever have a criminal prosecution. But I think ultimately that is deeply unsatisfying on two levels. The decision of the House of Lords from 1992, where there's a videotape that the police come across and then lay charges with no complainant, no suggestion that the activities were anything other than consensual. And I think that that's still a live concern in Canadian law. And I think, you know, at a more conceptual level, the kind of harm that is caused by those who engage in non-normative sexual practices, about always sort of, you know, dwelling in the shadow of the criminal law and always being concerned, exactly as you say, about, and what if something, you know, goes wrong. So I think that that's the standoff, and I'm not sure that we will ever be able to resolve it.
Can I just back Kyle up on those last points, because I really agree with them. The Brown, the English case, is amazing, because the police were investigating something else. I forget what it was, and they stumbled on this thing and prosecuted. And it was in that sense a clear case, in the way the Canadian cases are not, that this activity, which I found it difficult to read about, I have to admit, was nonetheless clearly consensual. And by a 3-2 majority, it was only 3-2 in the House of Lords, by a 3-2 majority, the House of Lords said, well, this is not a manly diversion like Rugger, and so we're not going to recognize consent in this context. And 2 of the law lords would have. So it was a very close thing. And so So yes, it may be unlikely that you will be prosecuted, but it could happen for that kind of reason or for the kind of reason Brenda gave. But I'm going to give a more abstract reason why I find this unsatisfactory, which is that notwithstanding all the uncertainties and perplexities of the criminal law, I think you should be able to look at the criminal law and have a pretty good idea as to whether what you're doing is legal or not. And you should not be going around thinking, geez, I'm doing this illegal thing. Wow, this is really fun. I'm doing this illegal thing. You know, I think you should be able to get a sense of what it is, of the lawfulness of what you're doing. And if the law is telling you this is illegal, I think that's quite problematic, even if the prospect of conviction is remote.
Can I just ask a quick, I'm just curious, you've
Yeah.
talked more than once, both of you, about Brown, but
Brown.
it sounds a whole lot like Spanner.
It's the same.
It's the
Oh,
same
same,
one. Okay,
yes.
I just want to be sure.
Yeah.
People,
Spanner was the police investigation,
Got it,
and
okay.
then Brown is the actual name of the accused.
There was Brown was one of them, Lasky, there were several of them, yeah.
and I think one of the things that Kingsters know about, and we call it Spanner, we know it as Spanner, is that one of the key features was that there was at least one person in that bunch who was actually convicted of assaulting himself.
That
Right?
can't,
Like, I mean,
that
it's
can't
really-
possibly be correct.
I'll take your word for it.
We'll have to,
because- but yeah.
no, we'll have to explore
That's
this
the
later
lore.
because this is actually not
Yeah.
possible under
Yeah.
Canadian law.
Even the law has its own limits. In some way, I guess maybe sort of following up on some of what you just said, Andrea, is maybe you can talk a little bit, and this is part of the not knowing whether the activities are legal or not, and yet living in the shadows of possible criminality, is to talk a little bit more about how law enforcement does interact with the Kingster community, and some of what you alluded to at the end around the kind of failure, the failure of a range of systems in terms of their interaction with the BDSM community.
Yeah, thank you for that. So, I think that so in the framework of the sort of two approaches to sexuality, the normal versus deviant, and the more or less consensual versus non-consensual, I think that the more assimilationist model has actually been very successful, at least to a point, because nobody blinks an eye at a black leather jacket anymore, right? Like there's a level of acceptability in the mainstream. But maybe not surprisingly, the kinds of kink that sort of don't work in a yogurt commercial, people don't know what to do with that, and they end up being further marginalized, right? So what you have is even sort of, historically speaking, sort of organizations like the NCSF, the National Coalition for Sexual Freedom, which is a US-based organization, doesn't really do much work in Canada, but they're kind of the only organization doing that work at all, so they become a reference point. And for a long time, they did a lot of work to sort of distance themselves from more extreme, quote unquote, or perhaps spectacular kinds of kink that they felt would sort of not do anybody any favors. So like a sweeping under the rug, right? So that's even within our own community that sort of happens. And another sort of result of that same split in model approach is that another group that gets marginalized often. So far I've been talking about BDSM as it takes place during a scene, right? Sort of you've negotiated a thing. At time A, the thing starts. At time B, the thing ends, and then you're back to normal afterwards, right? So a very sort of explicit container. So this model also, the sort of more assimilationist model, also tends to try and distance itself from people who do BDSM outside the context of a scene, which is to say people who incorporate it into an ongoing relationship of dominance and submission that is actively chosen and actively negotiated in a broad relationship sense rather than in a scene-by-scene sense. So for instance, things like people who do extensive negotiation for ongoing consent, as in you can do X anytime you want, right? It doesn't have to be negotiated, and this sort of gets into...
Yeah.
Right, exactly, right?
That's hugely problematic under the JA decision.
Exactly,
I think, yeah.
right? Whereas that for some people is the thing that works the best for them in a relationship context, right?
Yeah.
Same thing with, within the limits of A and C, you can do anything you want, right? So for instance, as long as I don't have to go to work with visible marks the next day, you can do anything you want and it doesn't have to be, the particulars don't have to be negotiated. So obviously this is not something that you jump into with someone after, knowing them for 2 weeks. This tends to be the kind of thing that's in context of very long-term relationships or ones that are sort of on the path to being. This isn't play exactly, it's something else. But it gets murky, and the organizations, even within our communities, sometimes try to pretend that's not really happening because it's not as easy to talk about. And as a result of all of this, the people who are sort of thrown under the bus are the ones who are at the greatest risk of the things that the people doing the defense are also, but less so, right? So, for instance, we're very aware, and again, because the bulk of the literature comes from the States, I don't know how it interacts with the Canadian context, but jail time, absolutely. Loss of child custody in divorce proceedings, if you can show that one parent was a pervert, you win, especially in a context with a lot of religious right input into a legal system. Loss of job, up into the upper echelons. Jack McGeorge, what the heck was his actual name? Well, yeah, okay, so Jack, anyway, really, that was easy. There's somebody else I'm thinking of too. Anyway, but there was a case a number of years back before he died that somebody who was very highly placed in defense, I think it was, like he was doing arms inspection in the States, was outed as being kinky, and his boss basically said, he offered his resignation. And his boss said, it's fine, stick around anyway. And it worked out, but it was one of these sort of super, super visible, deliberate outing strategies that could have resulted in him losing a lot. And because we're really aware of these social consequences, and then also you get into the legal ones. So spanner is one that we refer to a lot. Another one is, we call it paddleboro. It's actually Attleboro in the States, where some police sort of invaded. I think they were looking for drugs or had received some sort of, if I understand it correctly, a malicious tip-off. But they went into a BDSM play party as it was ongoing and arrested a bunch of people for assaulting each other because they were having consensual play. And the same thing has happened in Canada in less dramatic ways. I am aware of law enforcement having sort of stumbled into things, or somebody was making noise, and so the neighbor called, and these are the things that we're always really aware of. So we have all these paranoia about soundproofing, and right, but we're very aware that basically the police are not our friends. We don't as a group, we generally don't see law enforcement as being on our side. We see them as people to protect ourselves from. Right? So it becomes this self-fulfilling prophecy where you get a bunch of people doing edgy, kinky things who have a very different idea of how consent works than average, and who don't feel that law enforcement is going to help them. So what do you think becomes ripe territory for predators, right? People who aren't going to report, who won't be successful if they did report, and who, well, really it would be very easy to dismiss it anyway. And that's what we see in the research that's out there. The idea of a kinkster reporting to the police that they were assaulted during a scene is like myth, like it just doesn't happen. It's just known that that's not the way to go, right? Because you could drain down your whole community, it creates a giant mess, and nobody wants that, so, it just doesn't happen. And that means that we have to self-regulate, and our attempts to self-regulate are, sometimes spectacular failures, sometimes more or less successful, and I would say at this stage of the discussion, very much still in process. Right? I think that older models, when, pre-internet, when BDSM was happening, it was happening in a context where everybody who showed up was vouched for and known, right? It was a much more insular community. But all of a sudden, when you get much higher visibility and with that higher interest, you end up with a situation where you've got an influx of newcomers who may or may not, how do you can trust them just because they're wearing leather pants, right? Like it's not a useful barometer anymore. And so we've had to come up with strategies, and sometimes that looks like really nasty infighting and community politics. Sometimes it looks like, regulating access to events by all kinds of means, whether it's dress code or gender or, particular, proclivities, right? But I mean, and we don't have like our own little court system. We don't, right? It's very much dependent on the politics of a given group. So it's problematic, and my best thing is we're working on it. We, in this really broad sense, various groups and people are working on it, but there is no real answer yet. Yeah.
So why don't we open it up to some questions and comments from the audience? I can't imagine there'll be any. Way up at the top, red shirt.
Sexual
I think that's a really terrific question. I like Cynthia Lee's work on the reasonable man in the United States. In Canada, I think that if you were to sort of look at the theory of sexuality that's deployed in a case like Mabior, which is the case involving the most recent case, 2012, from the Supreme Court, involving HIV non-disclosure, you sort of see this almost rational actor model of sexuality being animating the jurisprudence about and you start to imagine that if you were to say all the things that the Supreme Court seems to want pause folks to say prior to engaging in sexual activities, very few people would have sex, right? It doesn't seem to, there seems to be a bit of a disconnect between the sort of, jouissance of sexuality, the breaking of, the distinction between the mind and body, and the ways in which jurisprudentially you see courts really trying to deploy this rational actor model and the precise language that people living with HIV have to use in order to avoid being charged and convicted of aggravated sexual assault. So I think it's a really interesting, in terms of thinking about pulling apart the theories of sexuality that are animating a lot of these recent cases.
No, I'm not being fed to that.
Okay, Jerry.
Three of you mentioned, we spoke a little bit about what a socially valuable activity is and how the court has defined what activities are socially valuable for the purposes of consenting to bodily harm. And I'm wondering how the court defines socially valuable activities. Is there a test for determining which activities are, or is it just how the court is feeling that day when a case is before them?
I don't think there's a test. In Jabadon, the court was, one of the interesting things about Jabadon is that it can be read very narrowly or very broadly. It can be read narrowly as being about fistfights, or it can be read broadly as being about who knows what it's about. So there's no test is articulated for what's a socially useful activity, but the court mentions a number of features of fistfights which contribute to its conclusion that here's a context where we are not going to recognize the legal effectiveness of someone's consent. They don't seem to have any value, that they seem to hark back to an older time where you would settle your differences by combat instead of by some other means, that they can lead to larger breaches of the peace, which was actually true on the facts of Jabadon. These two guys were pounding on each other and their friends got into it also. There was a concern about the sanctity of the human body was mentioned. These were some of the things that were mentioned in Jabadon for not recognizing the social utility of fistfights. And so when you move into another context, the court is going to ask itself, I guess, well, what are the features of this situation that make us think it is or is not socially useful? And what worried me about Welsh, there's all kinds of problems with the facts in Welsh, but what worried me about Welsh on the question of social utility was that the court seemed, in that case, there was almost a kind of circularity about it. That is, the court said, well, this is degrading and dehumanizing. Well, why? Well, the complainant was badly bruised. And if that was non-consensual, that certainly would be degrading and dehumanizing. But what if it was consensual? Why would it be dehumanizing for her to choose that for herself? Now, maybe it is. I'm not saying it isn't. Maybe it is. But there wasn't a lot of argument in the case as to why it was. And that's why it's so interesting in Jiao that the court is now not so sure that it was right in Welsh, which I think is really intriguing. So the short answer is there's no test. The long answer, I don't think it just depends on how the court is feeling that day. I think there's more to it than that.
Gary, way at the back.
Yeah, I don't know if people upstairs are going to hear me, so maybe you could relay it, because I suspect...
Can you hear? They can hear.
They can hear. They can hear.
They can?
We're getting thumbs up.
Two comments that maybe people can comment on. One, clearly notions like what is socially valuable are entry points for dominant social ideology into legal decisions. So that should just set off alarm bells for all of us. But what has been most striking for me about the presentation tonight, and I think it's because become most visible because of the sort of disjuncture in talk between Andrea and the three people more associated with the law on the panel is in a certain sense just how the law does not fit. There's a disjuncture between our lived experiences of eroticism and how we produce and practice consent and the legal regime that actually could potentially criminalize some of those activities. But I want to draw a connection between two different types of experiences that I think might provide a way out of some of the impasses that seem to be produced around some of the debates that are going on, stemming from the issue that led to the emergence of this panel, which is those disjunctures in experience are not simply experienced by practitioners of BDSM consensual practices, but they're also experienced by people who experience sexual violence and assaults in their lives all the time. So there's disjunctures then with the legal process and with the criminal justice system that actually could potentially provide bases for alliances between different groups of people that I think would be useful to pursue. And the common problem then is how the legal system actually criminalizes, on the one hand, consensual erotic practices by not understanding how they're actually related to people's lives, and on the other hand, how it ignores systematically forms of violence, especially gendered violence, and we really need to be able to bring those two conversations, those two struggles together. Thanks.
Can I say something about that, about the lived experience piece, which is not my lived experience, but this occurred to me also while Andrea was talking after the formal presentations. If there's ever going to be, one of the weird things about effecting social change by means of litigation is that you have to work with the structure of litigation, which means you have to prove your case. You have to demonstrate the facts, which you say entitle you to whatever outcome you're seeking or whatever remedy you're seeking. So, can Andrea, for example, be an expert witness in a test case to explain to a court how it is that you can I'm not even going to go into the details, how it is you can do some of these things without seriously hurting someone, which seems very counterintuitive. Or could it be someone else? How is the court going to know about your lived experience, let me put it that way? And how are you going to bring that into, if you do have a case with good facts that somehow you want to make it into a test case, there's going to be procedural and evidentiary obstacles that will have to be negotiated. That's what your question made me think of.
I was just going to say that the National Judicial Institute does all kinds of anti-oppression training to try to get the judiciary to better understand the lived experiences of a series of different racialized communities, gendered, et cetera, et cetera, et cetera, et cetera. They do these seminars. And you could imagine a scenario where BDSM practitioners wanted to do a seminar so that, not just purely in the domain of criminal law, but in employment law, in child custody cases, you could imagine a scenario where discourses about BDSM are relied upon. And so I think that could be really useful to have, what tend to be older, normative, straight judges to better understand and appreciate the value that BDSM has for so many people in their everyday lives, right? So I think that there is maybe that's a kind of a Pollyanna answer, but I think that there is a bit of an opportunity for coalitions there.
And I have my own Pollyanna answer as well. I'm so not Pollyanna. But when it comes to thinking about these issues, I revert back on a distinction that I could deconstruct 17 ways to Sunday, but the distinction is absolutely between consent and non-consent. And again, that it's contested terrain. There are places where it's unclear what it is, and yet I want to draw an absolute bright line around if, on the consensual side, the law needs to get the hell out and stay out, and it would be, it would be fine. And I mean the criminal law here. I don't mean the way we regulate other things. And it is on, I think, that bright line that we could draw and build a whole range of alliances. Now, again, we can contest about whether there really is consent and this is where a lot of radical feminist interventions deeply trouble me. Because they want to actually blur the lines more between consent and non-consent. And I want to make the distinction between consent and non-consent as bright a line as I can in order to get the law out, while recognizing that there are some risks in doing so. There was a hand right here that I keep not seeing. Was it? Okay, yeah.
Yeah, I was thinking about the two cases and how they're predicated on a social normative, and that the minute you step out of what is perceived as a social normative, the social value, which is mostly balanced on a moral value, probably a degree of Christian moral value, can't see the social value of sexual and psychological health.
Yeah.
That comes from healthy sexualities and healthy sexual explorations, but they can see it in both cases.
Well, I think you have to explain it to them. Somebody has to explain it to them. That's what I was trying to get at by my answer about expert evidence, because,
I suspect they know.
well,
I suspect they know, and they don't want to be the brave heart that steps out and say, I get it. Because it puts them out of the normative, and living outside the normative is scary. Those of us who do it know it's scary. But we find our cultural structures and our legal structures really reticent to put up their hand and go, I think we got it wrong. I mean, I really applaud you for saying you think the Welsh decision was off base and possibly needs reevaluation.
I think it needs to be reconsidered. I'm actually not going to commit myself to the proposition that it was wrong. But I don't find, but I told you I was the old man here. But I do not find the reasoning satisfactory at all. And if you're going to support that result, you need something much more than what's there in that case. And that may not have been the ideal kind of test case I was referring to, because this was a case where there wasn't any evidence about this as a practice or as a culture. It was just, oh, she likes rough sex. That was, basically what it was. And so it wasn't the ideal case for exploring those issues from the point of view of evidence.
And I'll add in here that I think it's really important to notice that in this sort of establishing framework that we're talking about here around expert witnessing and social value and all of this stuff, that the work that is being done by places like the Bonham Centre for Sexual Diversity Studies and so forth, people who are studying the history of porn, the history of SM, the history of sex work from a non-pathologizing perspective, anybody who's producing scholarship, legal or otherwise, as well as cultural production, film festivals, who knows what else, right? Like, literature, we could look at a boom in publishing. I mean, all of these different sort of socio-cultural phenomena that can be pointed to as, look, it's more like rugby than maybe you think, right? Like
exactly.
Exactly. People do it. They watch it. They buy the T-shirts, right? I mean, the more you get a team. Oh my God, I can't even. Yeah, wow. This could go so many places. But you see what I'm saying? Like that even for those of us working outside the legal structure, the more sort of culture that we produce, create, curate, and historicize, the more sort of the more strength we have to lend to a potential set of legal changes. So you don't have to be a legal scholar to be doing really valuable work in this area by producing culture.
Yeah, I think that's right. Yeah, that's always a tricky question. The criminal code definition of bodily harm is any hurt or discomfort that interferes with the, I forget the exact definition, anything interferes with the comfort or of the complainant and is more than trivial or transitory. It's something like that. That's bodily harm. These cases seem to be imposing a slightly higher threshold, which is non-trivial or serious bodily harm. So one thing that passed through my mind when I was listening to some of the other speakers was whether transient pain maybe wouldn't even meet the definition of serious bodily harm for this purpose. I'm not sure about that. The bruising in Welsh was not contested that met the definition of bodily harm for the criminal code purpose. So it's hard to know where the line is. It's like many legal standards, it's like many legal concepts, it's a standard that applies to a set of facts rather than a line that is drawn in a clear way. And so I think the way to get a sense of it is to read some of the cases and see what courts have said does and does not constitute it.
Okay,
But-
there's a whack of hands. How about here and then over here?
So I want to ask a question that is a little more complicated about consent, and I think it's complex both for the women and the men. So a scenario of the type of play I know about which is a public kidnapping. So a situation where somebody wants to be publicly kidnapped, not necessarily in bodily harm, but screaming, fighting, stuffed against their will into a van and zipped off and then screaming in front of in a public place, and the ways in which the law and look at where that might fall in terms of legal response for all kinds of reasons.
Well, it's not kidnapping if you consent to it. I think the danger of that is what kind of intervention might you expect from any police officers or even ordinary citizens who might observe it.
And the risk of bodily harm might in fact be that, you know, Bob on the corner punches out one of the kidnappers and not so much that the kidnapping itself is hurting anyone.
Yeah. Yeah, exactly. Or a police officer might use a degree of force to, yeah.
So, my question is that in reading these cases, I don't actually just think the courts don't get the BDSM thing and are just a bunch of old fogies who think that these people are wrong. I think they're very, very concerned about sexual assault. And they're very, very concerned about opening the door for those accused of sexual assault to basically claim that it was some form of BDSM and then force the Crown to prove otherwise.
Yeah.
So, to what extent does a court or the judiciary have the right or the responsibility to protect those who are sexually assaulted, even if that means limiting the rights of those who engage in something like BDSM?
I think that, yeah, that's the fundamental tension, right? So, for example, in the Supreme Court of Canada decision in Chuck, Supreme Court says there's no ability to provide legally valid consent on an implied basis, right? No implied consent. And so a lot of the, even some of the ways in which BDSM is often framed as being, you know, it's in the context of a much larger relationship, and you think about some of the ways in the scenes that have been consented to in the past, and that raises a series of red flags for the 1983 reforms to the criminal code and the jurisprudence in a case like Chuck, because there's no version of implied consent. It's in JA in 2011, the Supreme Court says it's part of this active, operating, conscious mind in the moment. So it doesn't matter if you consented a week ago. And actually, a lot of feminist legal scholarship has been very critical about the ways historically that evidence of past consent has been used and restaged in cases involving sexual assault because, as you said, the courts have often said, oh, well, she consented in the past, so she must have in the moment. And so I think this is the standoff that we see in the case law.
It's a huge tension, and PA, the decision I mentioned, which accepted, although that was not the issue in the case, accepted that a kind of role-playing without bodily harm would be perfectly fine, has all of those tensions in it. Because the court had to look at the sexual history of these two people, the history of their relationship, in order to understand what was going on at the moment. And normally, in sexual assault cases, courts are not supposed to do that. Normally, they're not supposed to look at the background history of the parties because that creates space for a series of unwarranted assumptions about you consented then, therefore you consented now, which is an impermissible inference in our law. And I don't think the PA decision makes any sense at all unless we have a conception of implied consent. The court doesn't talk about that. This is all in the background. But let me tell you the most shocking fact about PA, which is that the evidence was the complainant was saying no, no, no. Now, we all know that no means no. But in the context of this particular role play, no didn't mean no. Or at least that was the accused position. And the court accepted that that might be possible, which actually really surprised me in light of the 1991-92 amendments to section 273.1 and 273.2 of the code. And so that, I think, is a really good example of the tension you're talking about. I don't have a solution right now.
I can maybe just offer a thought, right? Which is, I don't know if it's useful from a legal perspective per se, but I could imagine it becoming that way if there were such a test case, for instance, would be the ways in which BDSM practitioners can demonstrate evidence of two things, both of prior and ongoing consent. Like, what are the signals that you would be looking for that have been discussed that you know mean ongoing consent? And also, in the same way, prior or ongoing, what's the out, right? So for instance, we often talk about safe words. They're by far not the only mechanism, but they are one mechanism. So in a role-play scenario where someone wants to be able to scream, no, 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 don't do it, and have it mean, please go on, this is awesome, then if it's actually going wrong, what do you do instead? Well, you yell grapefruits or something, right? And that is one way, if there is an established, recognized safe word, that you could say, but we talked about this. There was a way to say no, and it wasn't said, right? And the more you can, people who do ongoing BDSM relationships are often fans of written contracts, right? Like, some of them many, many pages long. Some of them are agreements in principle, but some of them are like full-on 12 pagers with clauses and stuff, right? And it would be important in that to say, for instance, that by the following set of actions, that the submissive party could dissolve this at any time. Right? And that's something that's done, right? Like, that is actually done. So that would be the kind of contract that perhaps could be held up as evidence saying, look, this was consensual because here was the way out, and the person chose not to take it even though they knew it was in place and so forth, right? So, there's these sort of, and in that sense, I think that it becomes, if we want sort of BDSM practitioners to sort of cover our asses, those sorts of things, the more documented and clear and carefully negotiated that we can make them would be the most valuable defense, I think. And the absence of them would be the thing that would be most likely to sort of point to something that was perhaps not as consensual after all, right? And it's partly the doing of it, and it's partly the having it documented, I think. I don't know how that intersects with the law,
I think it intersects quite well. There has to be room to withdraw consent under, in any sexual interaction. There has to be room to withdraw consent, given the way the provisions of the criminal code are drafted. And so then the problem is, well, what is the particular way of doing it in this situation?
I've been discriminating against the top row, sorry. So, over here.
I'm not sure what to say about that. It's there are cases which say that psychological harm can count as harm for the purposes of the criminal code, but then they don't seem to be, those ideas do not seem to be systematically deployed throughout the criminal law, is I guess what I would say about that. I'm sorry, I'm not sure I can add anything.
Yeah, and I'm not sure I've seen in all of the cases decided post-Walsh, there's nothing that's about psychological harm. There is actually some engagement of physical harm.
Yeah.
So, but it's a really interesting ongoing question. Maybe one last question. You've been trying to get your hand up for a while. Black, yes, yeah, you.
It's okay. I'm thinking through, I'm wondering, I guess, about the comments about sort of the court's fear of addressing issues of BDSM more fully for fear of somebody victims of sexual assault. And
Yeah.
to get past this, like, this was the re-victimizers women and question their ability to give rational, or to give consent.
Well, the prosecution has to prove its case beyond a reasonable doubt. So the prosecution has to establish non-consent as an element of the crime. So whether that's easy or hard to do in any given case really depends on the evidence in that case. And I do think that one of the more, there's still a lot of problems in this area, of course, but I do think that the reform that was intended to prevent fact finders from knowing about the complainant's sexual history has largely been successful, actually. It's now, with respect to previous sexual conduct with people other than the accused person, it's now very rare to see that kind of evidence being led in sexual assault cases, which I think is a great step forward. With respect to the particular accused, that is also presumptively inadmissible. It becomes more complicated because sometimes you need a context to understand the particular interaction that's at issue in the case. But I do think that's actually been a relatively successful reform. It gives me some hope.
And as a follow-up, I wonder if, so I know that recently there's been a move towards changing the sort of how consent is understood to sort of yes.
Yes. Yeah.
I wondered if anybody might comment on how, whether that's a useful change, how might consent look to get past this issue. I know this is for BDSM, not necessarily sexual assault, but I think this has become very special over the last couple of weeks. Jian Ghomeshi, that there's something about it.
I guess I would just say to that, we do have, allegedly operating the law, a far more robust notion of consent than we've had in the past, and that's a good thing.
Yeah.
Whether it always feels like it plays out that way in individual cases is another story. And I'd also say that I guess part of the problem is, bad facts make bad law. I mean, sometimes good facts make bad law too, but bad facts make bad law, and most of the cases that there has been any allegation of BDSM don't involve BDSM at all, right? They were just outright cases, in my humble opinion, of sexual assault where there was no consent. And somebody tries to argue that there was consent and this is just rough sex. It's where there is this, the allegation of the BDSM defense, which, as I say, is neither BDSM nor a defense. And so we end up in this place with all these comments on BDSM when, in fact, that wasn't what it was about in the first place. So, by trying to keep on this more robust notion of consent, and in fact, the courts in most of the cases kind of get it right insofar as they say, you know what, dude, there was no consent here, so we're not going to the what if there was consent? Could you consent to this? And that's where that sort of remains as an open issue. I know we're kind of out of time, so having just abused my role as the moderator to get in the last word, which will neither be the first or last time I will have done that. Let me thank my incredible panelists, co-panelists. This has been, I think, just an absolutely fascinating, engaging, funny discussion about some pretty serious topics. So thank you all. And thank you all for coming.